Good morning. Good afternoon. Today we're going to continue with the part 2 of the topic that we started last time. And the topic is the nature of business. The nature of business. You remember we're trying to understand what businesses are all about. So in our previous topic, we did look at the nature of business in terms of for-profit businesses as well as not-for-profit businesses. So we are going to continue with understanding the nature of businesses by now appreciating what a business is from a legal perspective. In other words, in terms of the law, how should we understand a business? So therefore, our topic today is the nature, the business as a legal entity. The business as a legal entity. So if we were to try to understand businesses from a legal perspective, the basic legal distinction between the types of business enterprises is in terms of their status. So the law helps us to understand what businesses are in terms of their legal status. So from this, we understand businesses by dividing them into two broad categories. And what are these two broad categories? The first one is called non-corporate organizations, and the second one is called corporate organizations. So from a legal perspective, we can understand businesses in terms of either those businesses being a corporate organization or that business being a non-corporate organization. So let's start with non-corporate organizations. What does the law say are the non-corporate organizations? Non-corporate organizations are those which do not have a separate legal identity from their owners. Non-corporate organizations are those which do not have a separate legal identity from their owners. In other words, what we're saying is when we look at the owner of the business and we look at the business itself, these two are regarded as one and the same. In other words, if I'm running a business and it's called 10 miles business, 10 miles investments, for instance, 10 miles investments, that's the nature of my business. If it's a non-corporate organization, when we say they do not have a separate legal identity from the owners, what we're saying is, when you look at the 10 miles investments as a business, and when you look at me as a person, we are one and the same. Meaning that if something was going to go wrong to that particular business, we can sue the business or we can sue the owner. The owner and the business are one and the same. That's why the main forms of non-corporate organizations are therefore sole traders and partnerships. So examples of non-corporate organizations or forms of non-corporate organizations normally fall into these two broad categories, that is sole traders and partnerships. Sole traders sometimes can be referred to as sole proprietors. Okay, so sole trader or sole proprietor. How about corporate organizations? What can we say are corporate organizations? So corporate organizations are those where the legal status of the organization is separate from that of the owner. Are those where the legal status of the organization is separate from that of the owner. So, what do we mean when we say that? What we mean is, when we look at the business, let's say, Mosa University, and we look at the owners of Mosa University, we are going to say that these are two separate legal identities. So Mosa University will take a particular legal identity which is separate from that of the owner. Meaning that should something happen to this particular organization, we can only sue the owner. I mean, we can only sue the business, but not the owner, because these are two different persons. So corporate organizations are those where the legal status of the organization is separate from that of the owner. To understand that further, maybe we can appreciate the categories of corporate organizations. Categories include, or types include, private limited companies and public limited companies. Okay. So examples of corporate organizations, these are divided into two broad categories. We have private limited companies and public limited companies. These are examples of what are called corporate organizations. The legal status of the organization is separate from that of the owner. In other words, the shareholders are totally different from the organization itself. Should something happen, should the organization be wrong in one or the other, the organization itself is what is going to be sued, not exactly the owners of that particular organization. So I've said examples of such organizations basically are what are called private limited companies and public limited companies, PLC as normally they are abbreviated. Let's start looking at these two broad categories of organizations, the corporate organizations and the non-corporate organizations, in broad terms, starting with non-corporate organizations. So like I've said, the main forms of non-corporate organizations are divided into two broad categories. So we have A, sole trader, and B, partnerships. When we say sole trader, what are we talking about? A sole trader, this is a type of business which is owned and managed by one person who provides the financial resources and makes all the business decisions. Since the owner makes all the business decisions, he or she is responsible for the success or failure of that particular type of business. Okay, so in this type of business, we have a single individual who will start the business, and this particular person will be responsible for making all the decisions of the organization. If those decisions are wrong and the organization is unsuccessful, the unsuccessfulness of the business will be attributed to the owner. If the organization will be successful, all the success will be attributed to that particular owner. Those are type of businesses I refer to as sole trader as a first example of a non-corporate organization. The second type, partnerships. Partnerships. So partnerships are also examples of non-corporate organizations. So when you say partnerships, what are we talking about? The legal definition of a partnership was put forward in the Partnership Act 1890, and it means the relation which subsists between persons carrying on a business in common with a view of profit. I'll say this again. The relation which subsists between persons carrying on a business in common with a view of profit. Meaning that a partnership is simply a relationship that will exist when two or more people carry out a business, and all these people have a common objective, and that is to make profit. Basically, that's what a partnership is all about. And the partnership is also an example of a non-corporate organization. Let's appreciate partnerships further. Partnerships offer a business the opportunity to share skills and workload, and most importantly, to raise more capital than would be available to a sole trader. That's one common advantage of a partnership, in the sense that when you have a partnership, you have different types of skills that will come from different partners, and that all the skills will benefit the business in one or the other. Another point is, in terms of the workload, since they have more than one person, you have 2, 3, etc., it means the workload will be shared amongst the partners. Another advantage is raising of more capital. Because you have a number of partners, each partner will actually bring in their own contributions as far as the capital is concerned. Unlike in a sole trader business, you only have one person with their own resources. If those resources are not enough, then the business will suffer. However, in a partnership, different partners will bring in different resources and will contribute, and this will be very, very important in terms of doing or establishing different activities, because there are more finances or financial resources available. Examples of partnerships. If we were to look in our society, what can we say are the typical examples of partnerships? So common examples of partnerships include the practice of doctors. Doctors normally, when they are doing their business, you find that this one doctor with one specialty will come up with a particular expertise, and maybe the other doctor will also come up with another expertise. They team together and they will form a partnership, and they'll come up with a good organization. Accountants, like those providing taxation services, for instance, auditing services, for instance, they will team up. Maybe the other one is a pure financial accountant. Maybe the other one is a management accountant. They'll form a partnership. Estate agents, architects, auctioneers, all these are typical examples of partnerships that you can think of. You can also be thinking of how you can apply these type of partnerships in your own lives. Probably you want to start a business. Are you going to start it as a sole proprietor, a sole trader? Or are you going to start it as a partnership? So this knowledge, I do not want you to use it just for academic purposes, but you can also think of applying it in your real life. You want to start in a corporate organization, you can consider to start a sole trader, or you can consider to start a partnership. So let's assume that you want to start a partnership. So you need to appreciate the different types of partnerships, the different types of partnerships that you can have. There are basically two main types of partnerships. So we have ordinary partnerships, and then we have what are called limited partnerships. Let's start with ordinary partnerships. What can we say are ordinary partnerships? So there are two types of such partnerships. That is, there are two types of ordinary partnerships. The first one is partnership without a legal contract. And the second one is a partnership with a legal contract. All these two are examples of what are called ordinary partnerships. So in terms of partnerships without a legal contract, what can we say are partnerships without a legal contract? This is the simplest type of a partnership where the partners informally set up a business with no legal contract. So what we're saying here is it's possible to start a business and you start a business, but you don't form any contract in that particular business. You start a business, but you don't involve any contract. You don't come up with a contract to safeguard that type of business. That is called a partnership without a legal contract. So we need to appreciate that. Now, where under what circumstances can we have such a contract whereby you have a business which is a partnership, but then it does not have a legal contract? Okay, there are situations like when a family, let's say a husband and a wife, they opt to start a business. If they start a business, normally there is a high level of trust between the husband and the wife, or maybe family members, a brother and a sister, maybe sisters. They want to start a business. If they do, you find that they will not necessarily want to, involve themselves into, developing a contract or going to other lawyers. They're family members, they're related by blood, and therefore they feel there is a level of trust, nothing can go wrong. Those are the type of partnerships we're referring to as partnership without a legal contract. So the partners are jointly and most of the times share the dates of the business. So in this type of business, there's one aspect that we need to appreciate. This type of partnership, the business has unlimited liability. It will be the same as that of a sole trader. Meaning that if the business go wrong, the owners of the business will be liable for whatever problem is there. If the business has gone wrong and there are debts to be paid, the properties of the owners of the business, in other words, in this case, partners, will be used to settle the debts of the business. There will be no separate legal identity. These are the same, just like a sole trader. Partnerships with a legal contract. So ordinary partnerships, the second type is the partnership with a legal contract. Partnership with a legal contract. This is where there is a formal partnership agreement or deed of partnership between owners. The existence of a formal deed avoids disputes on how work and profits are to be divided. So what we're saying is, it is also possible to come up with a legal contract, to come up with a partnership, but that partnership, although it's ordinary in nature, it is going to have a legal contract. So this is where there is a formal partnership agreement or deed of partnership between the owners. So in other words, you develop a contract with your brother and a sister. So, okay, here is how we're going to do the work. Here is the profit ratio. I'm going to contribute 20%, you're going to contribute 80%. So when we make profits, I'm going to get 20%, I'm going to get 80%. Let's put that in writing. In terms of work, probably since I get more, you are going to be getting this type of profit, or you're going to be getting, in terms of workload, this is the kind of work that you'll be carrying out. And this, because you get less, you work less. You work more, probably you also get more. Okay, let's look at the other type of partnerships. Apart from ordinary partnerships, we can also have what are called limited partnerships. The Partnership Act 1907 states that a limited partnership shall consist of not more than 20 limited partners and include one or more persons who attend general partners. So basically, that's what we can say is a limited partnership. It will consist of not more than 20 limited partners and include one or more persons who attend general partners. So in other words, in a limited partnership, you're going to have two types of partners: general partners and limited partners. Let's try to appreciate what will be the difference between these two. Who is a limited partner and who is a general partner? General partners have unlimited liability, whereas limited partners have limited liability. We have to understand this term of limited liability or unlimited liability. What we call unlimited liability, it means when something goes wrong in the business, the resources of the business plus that of the owner of the business can be used to settle whatever has gone wrong to that particular business. That's why it's called unlimited liability. But when you have limited liability, your liability in the business, should something go wrong, will only be limited to the amount of contribution. In other words, shares or money that you contributed to that business. And that's it. Okay. Corporate organizations. Let's appreciate corporate organizations further in terms of limited companies. In other words, we've already indicated that limited companies are also part of what are called corporate organizations. In legal terms, a limited company is an organization that has a separate legal status from those who own it. I've already explained that. And this means that all the assets belong to the organization and not to the owners. This is where most students need to be able to make a distinction. If you are running a limited company, it means a limited company assumes a legal identity. It's as good as a person on its own. The owners of that particular business are also separate, and they've got their own legal identity. Should something go wrong in a limited company, you are going to sue the business. You're not going to sue the owners of that particular business. And that's why we say that the owners of that particular business have limited liability. The owners of a limited company are referred to as shareholders. And these are the people that have invested their money in that particular organization by buying shares. In accounting terms, what are called ordinary shares in that particular company. The proportion of the company that they own is known as the equity, and hence ordinary shares are often called equity. In other words, if you're a shareholder, you own a certain level of shares in that particular company. Those shares are referred to as equity. So depending on the size of the organization, sometimes you have a large equity, sometimes you have just a low or small equity. If the company fails, the owners are generally not responsible for settling the company's debts. Why is that? We've already explained that the legal status of the business is separate from that of the owners of the business. So the shareholder's liability, if we're to take to task the shareholder, their shareholder's liability will only be limited to the amount of equity they own, and would lose only that amount they originally paid for those particular shares. Okay. In other words, what we are saying is they're not going to suffer any other loss apart from what is their own shares. In other words, the amount of money that they paid for their shares is the only amount of money that they're going to lose. If the company fails, the owners are generally not responsible for settling the debts. So the shareholders' liability is limited to the amount of equity they own, and would lose only the amount they originally paid for those particular shares. But there is an exception. The exception is where the owners probably have secured a loan or loans from financial institutions. Let's say you're running a limited company, but then the owners, in other words, the shareholders, secured a loan or loans from financial institutions. So this would be seized by the financial institution if the business failed. In other words, the financial institutions that offered that particular loan can actually go to that particular institution and grab property because of the loan which a particular shareholder got from that particular institution. So shareholders often take no part in managing the company for this particular reason, because they are separate from the business itself. The business is another person, shareholders are another person. So for shareholders to be successful, or for their organizations to be successful, they normally appoint managers to run their organization. Then they will be outside the organization itself. Forming a limited company, that's what we also need to appreciate as far as understanding businesses is concerned. What does it take to form a business? We need to ask ourselves that particular question. Some of you in future, you may want to form your own businesses. If you are to form a limited company, what kind of stages are you going to be involved in to form that kind of company? That's what this topic is all about. So companies normally have 2 or more individuals wishing to start a business together. They are required to file a number of documents to establish a limited company. So if you have to start a limited company, you need to prepare and file a number of documents. These documents, you are going to take them to the registrar of companies. So what are these documents that you can prepare? The first one is referred to as articles of association. So what are articles of association? This is a document which sets out the rules by which the shareholders and the company will be administered. For example, voting rights, powers of directors, etc. You see, to run a company successfully, you have to be able to set out the rules which shareholders and the companies will be administered. Otherwise, in that particular company, if you don't, everyone will be doing whatever they want. At the end of the day, there will be chaos and the company will fail. So to avoid that, you have to prepare what is referred to as articles of association. You'll find that your company will be able to run smoothly. Second document that you're going to prepare, Memorandum of Association. So Memorandum of Association, this is a document that sets out the company's name, status, address of the registered office, objectives of the company, statement of liability, and amount of guarantee. All these things, they need to be very clear in the company, and you prepare a document called Memorandum of Association. Normally, this document is prepared with the help of lawyers. You can ask lawyers to assist you to prepare Memorandum of Association. The third document that needs to be prepared is referred to as a statement of capital. This gives details of the types of share or shares, the amount of paid up and unpaid up on each share, the number of shares issued, the nominal value of shares issued, voters' rights, and the shareholders' details. So that is called statement of capital. You need to know what are the details of the types of shares in that particular business. Which shares have been paid up and which ones have been unpaid up. When we say paid up or unpaid up shares, what do we mean? Sometimes it's people for shareholders to buy shares, but they have not fully paid for all the shares. So those will be referred to as unpaid up shares. Those that are fully paid for, those will be called paid up shares. So a statement of capital in a business, when you're forming a company, is key to ensure that that business will be successful. Sometimes you are running a public limited company, so you need a fourth document. This document is referred to as a prospectus. So when we say prospectus, what are we talking about? So public limited companies must also issue a prospectus which describes the history of the firm or the organization, its future prospects, and the terms on which it offers its shares. So a prospectus will spell out the history of that organization, what has been happening in that organization, how did it start? But it will also spell out the future. So what do you feel you're going to gain as an organization in the future? What are the future prospects of that organization? And then the terms in which that organization will offer its shares. You see, this document is important because this is a public limited company. Sometimes you would want to share, you would want to sell shares in this particular public limited company. So you use the prospectus for people, for potential buyers of your shares to know what is happening in that particular company. What's the history like? What's the future like? Is this going to be a successful company or not? So that you help them make a decision to buy their shares and therefore contribute capital to your business. So types of limited companies. What are the typical types of limited companies that we need to know? Well, there are three types. The first one is called a private limited company. Second one is called a public limited company or PLC. The third one is called a company limited by guarantee. So most students know or pay attention to a private limited company, a public limited company, the second one, but most students may not maybe know a company limited by guarantee. So we need to know these three in terms of what they are, starting with a private limited company. So when you say a private limited company, what are we talking about? A private limited company is one in which the owners hold a percentage share of the value of the company. The one which the owners hold a percentage share of the value of the company. Meaning that you may have a number of shareholders and each one of them has a percentage shareholding of that particular company. Often, this is dictated by the amount of the capital sum or value of the property that each person contributed to that particular company. So what we're saying is, if you contribute 20%, maybe your shareholding will also be 20%. If your capital contribution was 30%, maybe your share percentage will also be 30%, etc. So to form a limited company, there must be at least 2 directors. Owners of limited companies, like we indicated before, have limited liability for the dates of the company up to the amount they originally invested. Owners of private limited companies have limited liability for the dates of the company up to the amount they originally invested. Public limited companies, or PLC, which ones are these? A public limited company is a company that trades shares nationally or intentionally. It can sell shares directly to the public or through an investing institution. So which ones are these? Where do public institutions trade shares? Normally, public limited companies will trade their shares at what are called trade or stock exchanges. I'm sure we have heard of the Zambian Stock Exchange. In the international, we also have certain stock exchanges that are opened up to international businesses. So a public limited company can float their shares on a stock exchange to attract investors. The idea of selling shares is that potential investors will buy the shares, and in so doing, they are contributing to the capital of that particular business. A PLC, or a public limited company, is owned by shareholders who have brought an interest in the company. Their liability is limited to the value of their original purchase of shares. Again, just like limited companies, your liability will be limited to the amount of shares that you purchased in that particular business. So if something goes wrong, you only be required up to the amount of money that you use to pay for your shares, and not more than that. The third type of limited company, I've said, it's a company limited by guarantee. So what kind of limited company is this one? A company limited by guarantee is an alternative type of company, usually used primarily for non-profit organizations that require a corporate status. You remember non-profit organizations are usually, let's say, NGOs. And they are called NGOs, but some NGOs would want to be called corporate organizations. So how can you convert a non-profit organization such as an NGO to gain a corporate status or to become a corporate organization? So these companies, they will do that by having an alternative type of limited company, which is called a company limited by guarantee. This company does not have share capital and has members who are guarantors instead of shareholders. In other words, such an NGO will not be called, the owners will not be called shareholders as such. They will be called guarantors. In other words, they will just guarantee the different activities in that particular company called a company limited by guarantee. So guarantee companies include clubs. So in other words, examples of companies limited by guarantee will include clubs, membership organizations, maybe sports associations, maybe some charities or NGOs. Those that choose to gain a corporate status, they may again be required to go through the processes that will make them be able to be called a company limited by guarantee, again by preparing those documents. Although being a non-profitable organization, those three documents, remember, memorandum of association, articles of association, and the other one, which we say statement of the capital. So although an NGO, if you prepare these, you file them with a lawyer, you take them to the registrar of companies, then you are going to have what is called a company limited by guarantee. Okay, so we need to remember that. Okay, now sometimes you may need to form an organization, but this organization, you may want it to have what is called a charitable status. In other words, you want to form an organization which is called a charity. And when you form an organization which is called a charity, that organization basically is referred to as a charitable status. So an organization may apply for charitable status if its aims are exclusively for the public benefit. If you want to form an organization and that organization is not for profit, and you want that organization basically just to benefit the public, then you can call that organization a charity. So what are the categories under which an organization may qualify to be a charity, or at least gain charitable status? Examples include educational advancement. If you form an organization simply for education advancement, if you form an organization for poverty relief, you want to alleviate poverty or reduce poverty. If you form an organization like for advancement of religion, if you form an organization for purposes beneficial to the community, all these four categories can be referred to as charities or charitable status organizations. What could be the advantages of forming an organization with a charitable status? So the first advantage could be, normally charitable organizations do not have to pay income tax or corporation tax or any other type of taxes. Normally they are exempted because they basically benefit the public. Another advantage, charities are perceived and regarded in a way that make it slightly easier to raise funds than it would have been in a non-charitable body. In other words, if you want to raise funding, it's very easy to get it if your organization has a charitable status rather than a non-charitable status organization such as a profit organization. What could be another advantage? Some funding is only available to charities. If you look at some funding, the funding can, if you're in situations where you require funding, maybe for profit organizations may not be given the funding. But for charitable status organizations, you find that they can be able to acquire funding. And another advantage is that the donors that are sponsoring those charities can receive tax relief. You know, donors, they also pay taxes, but if they're constantly giving money to charities, you find that those donors can actually be exempted of certain taxes, or at least maybe they can be told not to pay taxes for a reasonable period of time. So charities do not normally have to pay income tax or corporation tax and all these other taxes. Another advantage, if you are a charitable status organization, you find that even governments can actually recognize your efforts and support whatever efforts you are pursuing. How about disadvantages for organizations with charitable status? There could be some disadvantages, including the following. The first one is obtaining a charitable status can take a long time, and the organization is subject to considerable controls. You know, for you to obtain a charitable status as an organization, you have to apply to the Register of Companies. So the Register of Companies and the government would want to scrutinize why you want to become a charitable status organization or a charity. Is it that you just want to swindle people? Or is it that you want to help people in true faith? So the scrutiny may take a long time. So you may want to form a charitable organization, but then you find yourself waiting for months, even years, before you're accepted to operate as a charity organization. Second disadvantage, charity law also restricts what charitable organizations can do and how they are run, including that trustees avoid any situation where charitable and personal interest might conflict that employees of charitable organizations cannot usually serve on its governing body, for instance, okay, or maybe involving themselves in political campaigning, for instance. So if you decide to operate as a charitable organization, you find that there is what is called charity law, and this is normally restricting. You find that employees, the people that have started that charitable organization, will be restricted in a number of areas in order to maintain the integrity of the charitable organization. And you don't want a situation whereby the people that have a charitable organization have conflicting interests. Maybe they want to be seen to be making profit out of the charity organization instead of helping the poor. You don't want that to happen. So this is also a disadvantage that we need to appreciate. The last part of understanding the nature of business today, we're now going to understand the business from an economic perspective. So economists, unlike the law or lawyers, have their own way of understanding a business. Remember, we have understood the business, the nature of the business in three main aspects. The very first one, we understood the business in terms of profit. So we said we can have two broad categories of businesses. We have for-profit businesses, and then we have not-for-profit business. So that was understanding the business from a profit perspective. The second perspective, we understood the business from a legal perspective, and that's what we just finished talking about, where we have different types of organizations divided into two: corporate organizations and non-corporate organizations, having limited companies and unlimited companies, for instance. Again, the last part is understanding the business now from an economic perspective. So from the economic perspective, how do we understand the business? From an economic perspective, basically, we understand the business from what is called the transformational process. So economists look at businesses from the transformational process perspective. And what do we mean when we say the transformational perspective? Well, economists will be interested in these three main issues. The first one is that a business will have inputs. The second one is that the business will have organizational processes. And then the last one is that the business will have outputs. In other words, economists are interested in how the inputs are taken to various organizational processes so that that particular organization can yield outputs. So to have a broad appreciation of a business from an economic perspective, you simply need to understand what are the inputs of that organization, what are the organizational processes of that particular organization, and what are the outputs. The organizational processes are there to convert the inputs to become outputs. So first of all, probably we need to appreciate this transformational process by understanding those three categories. When you say inputs, what are inputs? So inputs are anything that you are going to take into your business to help you to have outputs. Outputs basically meaning products and services. So inputs, what could be the examples of inputs? Inputs examples could be raw materials. For instance, if you are in the process of baking bread or bakeries, your inputs will be flour. So any business will have their own type of inputs. If you're in the process of making motor vehicles, maybe your inputs will be metal, steel, aluminum. You need all these in order to be able to manufacture a vehicle. So when you have inputs, where do you take these inputs to? The inputs are taken to various organizational processes. So when we talk of these various organizational processes, we're talking about various processes that will help convert the inputs into the outputs, such as production processes. So if you're a car manufacturing organization, you need the aluminum, metal, you have there for various production processes to convert those aluminum or metal into typical various parts of the vehicle or a particular car, a finished particular car or vehicle that you may want to sell. Outputs are the finished products or services. So if you're a bakery, maybe the outputs will be bread or scones or whatever outputs that business will be able to have. Other examples of inputs that we need to appreciate, or for us to appreciate further what inputs are, apart from raw materials, from the economic perspective, we have to appreciate that inputs are also mainly the factors of production. So what are the examples of factors of production? Factors of production, we're referring to land, labor capital, and entrepreneurial skills. So land, labor capital, and entrepreneurship skills. So if you have land, you find that within the land, you can have so many things that you can use for as inputs. You can actually be able to have wheat. You can plant, you can start a farm to plant wheat, which you can use for the bread. Labor, you need people to work in organization. This is also part of input. You need capital, like financial resources that you will need to support that particular business. Again, you need the entrepreneurship skills, and the ability to identify opportunities and mobilize resources to pursue those opportunities. Those are entrepreneurship skills. Outputs. The outputs can be tangible, such as maybe shoes, clothes, skateboards, magazines. All these are examples of outputs. Sometimes they can be intangible if it's a service, like insurance services, education services, etc. So organization processes are those processes that will help you convert the inputs into the outputs. Okay, so why do economists or economists talk about this transformation process? We can answer that question by appreciating the uses of the transformational process. You see, if you understand the inputs that your business needs, the organizational processes that your organization will need, and the outputs that your organization will ultimately have, you can actually use this to be in a position to gain competitive advantage to your competitors, because you are going to compare your transformation process, i.e. your input organization processes, output process, you compare it with that of your competitors. Improve your transformational process by improving your inputs, your organizational processes, and outputs. In so doing, gaining competitive advantage against your competitors. And in so doing, improving your profit levels. Actually, if you understand this process, by even comparing with your competitors, you can even find ways of reducing costs. So from the economist perspective, we can actually benefit by understanding an organization from from an economist point of view, that is from the transformation process, by simply paying attention to three aspects. What are the inputs of the organization? What are the organization processes that will help convert the inputs into the final outputs of that particular organization? Right, thank you very much. This is what I wanted us to look at today. If you have any questions, please do not hesitate to post the questions on your WhatsApp group so that we make any clarifications should you need any. Thank you very much.